summarization.
So next month, there'll be a summary right now.
You don't have to be here when it's coming. There's no problem with the,
All right.
well, wait a couple minutes.
Gary just said roughly about his well. Training for the first round of the lab. He had a call. Well,
Mike.
no, I know. Oh.
What was Russell before?
I know. I would assume this the. I assume we're gonna have. Hey, just stop. Yeah. All right, at this time here, I'd like to call to order Coventry. Calling order. Shield. And I'd like to have, attention, the, roll call done, please.
Bob Probe,
Here.
Keith Cludier,
Here.
Len Doig,
Here.
Ed Ionati.
Yeah.
Ross Pelletier.
Here.
For the record, we have Solicitor Igliozzi
Here.
and Director Durfee.
Here. Thank you all for coming. I'd like to point out your fire exits are to your rear. These two exits to our rear take you into the building. So the only two fire exits are to your rear. Okay, we're at a point now where the board has heard from both and now we have findings of facts submitted by the appeal, and also we have findings of facts from the applicant. At this time here, I'd like to have the appellant please come up and summarize your Findings of facts, please. Give your full name and address so I can swear you in.
Arthur Mesquita, RUSTIGIN,
1 Hopkins Hollow Road in Green.
Okay, Arthur, would you raise your right hand? You swear to tell the whole truth and nothing but the truth in front of the board?
Yes.
Okay, please summarize your findings of fact.
Okay. In a short version of what I said last meeting, we are not opposed to this particular project as just this project. We have been quite active in trying to keep the western end rural, and we have been opposed to other projects that have tried to go in that spot and others. We are looking at 3 reasons why. One is lack of support by weight of the evidence. When the preliminary plan was discussed and approved by the Planning Commission, it noted over 20 deficiencies, some of them of significant, some quite significant, like DEM clearances, wetland clearances, DOT traffic studies, and such, as well as many others. And while those were going to be done through administrative action, we feel that it takes it out of the public view, that those kinds of deficiencies, even though they're cleared up, we would not know about them unless we put the effort in to go to town hall, check the record. In other words, it wouldn't have been another public meeting to let us know if those deficiencies had been cleared up. The other big contention was that it is inconsistent with the comprehensive plan. And while in the motion it states that generally it does meet the comprehensive plan, or is consistent with the comprehensive plan, we argue that while residential cluster developments are allowed, it is in the comprehensive plan. It's not literally a violation in that sense, but that there are a dozen or more quite emphatic statements in the comp plan that the western end should remain rural, no suburbanization, no urbanization, no intensive use, which we argue, or we would wish to have the Board of Appeals agree that 7 houses in a row on the street is definitely some form of suburbanization, urbanization, or intensive use, to be sure. And I offered in my packet several of those comp plan clauses that support that contention. And the final point was a procedural error based on due process rights. Understanding that rights are in some ways a citizen's responsibility to know the law. As I said in the beginning, we have come to years worth of meetings and never knew that there was an appeals process. When that came up at that August meeting, there was a lot of contention about what happened there. And then there was discussion about the right of appeal. And our argument is the way that discussion went was the Planning Commission and the town solicitor were not quite forthcoming in explaining the process. And as they discussed it, it seemed, well, yes, there are people, you can appeal these decisions. There was also a discussion that the applicant, were they to deny preliminary at this point, that they would just get an appeal from the applicant side rather than from our side. And the last contention there on due process, excuse me, is in the abutters letters. There was supposed to be a clause saying that the Planning Commission may revise their decision based on new evidence or topics that came up in public discussion. That phrase was not in the in the applicant's abutters letter. And as I said on the discussion about appeals, it appeared that at least some members of the board felt that planning commission felt that changing their mind at that point was, I don't want to say not allowed, but having already approved master, could they deny at preliminary? But several members of the planning commission did vote against it at that preliminary hearing plan, which we argue then you could change your mind. The planning commission could change its vote rather than be held to their original master plan decision. I believe that's the summary of my case. Thank you.
Okay, Mr. Cronin, would you please come up and give the applicants findings of facts, summary?
Sure. I'm not sure if what's popped up on the screen is interfering with the publication of the meeting. I just wanted to bring it to the board's attention. You have to look elsewhere for your IT advice. But
Okay, Mr. Cronin, please give your full name and address.
Thomas Cronin, Nolan Bernero Cronin Ferrara, 1070 Main Street, Coventry, Rhode Island, for the applicant.
You swear to tell the whole truth, nothing but the truth in front of this board?
I do. So taking the items in the order that Mr. Essegian presented them, the planning board found that there was sufficient evidence in the record to rely upon to make the decision to approve the preliminary plan. Briefly, as I spoke at the last meeting, we presented testimony from Sam Swarsa, who included in his testimony the design of the project, the approval of the subdivision suitability by Rhode Island Department of Environmental Management, the approval of the 7 driveway physical alteration permits by the Rhode Island Department of Transportation, the planning director's requirement that Mr. Swarsa adhere to the biologist's recommendations with regard to the identification of wetlands and the buffers surrounding those, including what he calls a vernal pool on the property. And in addition to those outside agencies which had input to the project upon which the planning board put their reliance, we presented a plan that conforms. So the Rhode Island state law refers to the Coventry subdivision regulations. The Coventry subdivision regulations contain cluster subdivision requirements for the RR5 zone. And the plan that we have presented, this 7-lot subdivision, cluster subdivision along Hopkins Hollow Road, complies with each and every one of those subdivision regulations with regard to area, frontage, setbacks, whatever is required, 50-foot front buffer, an additional buffer on the side of the project to any adjoining residents, in this case, that of Mr. Thornton. We have complied with each and every one of those items, and we did not appear before this board or the town council asking for any zoning relief. This is a conforming project. And then in addition to those items, which we presented to the board made 3 specific requests to us with regard to our project, which were over and above what the zoning and subdivision regulations called for. That the homeowners be responsible for the cleaning of the culverts and the drainage along Hopkins Hollow Road to the extent that was on their property. That a restriction on motorized recreation in the 20 acres we're preserving in the back, where they don't want kids on dirt bikes and ATVs riding through that property. And they were looking for a way to enforce that And they asked us if we would put that in our homeowners association regulations, that even the homeowners couldn't do that. Never mind, the neighborhood hoodlums, right? And we agreed to that. And so there were requirements that we agreed to over and above the subdivision regulation conformity. So briefly, that's our response to the first item, that the board did not have enough evidence to rely upon to grant preliminary plan. With regard to the comprehensive plan, this is a little bit of misdirection before this board. Comprehensive compatibility of this project with the comprehensive plan was presented at master plan to the planning board. That was the whole idea, right? We presented a yield plan, a regular 7-lot subdivision on 5 acres, and we presented this cluster subdivision, 7 lots on reduced size, but maintaining the 20 acres in the back. And we had a whole hearing in which many of these folks appeared before the planning board at master plan. And after they heard that item and those arguments, including comments from the public, they approved master plan for the subdivision, cluster subdivision with the 7 lots on the reduced acres of land that preserves the 20 acres in the back. And when they did that, that became our vested right. Right. We planned our project based on their approval. We went out and, submitted to DOT and DEM, made designs, and we came back to preliminary plan in reliance on that authority from the planning board at master plan, that this plan was in conformity with the comprehensive plan. They actually voted 9-0 at master plan, that this was in conformity with the comprehensive plan. And so we relied on that as we proceeded. And at preliminary, when the neighbors raised that question, I did caution the board that, we had obtained vested rights to proceed with this cluster subdivision based on that master plan. I point out in my findings of fact, I quote from the subdivision regulations, that is the appropriate time in the process of a project to have that comprehensive plan decision made. It's at master plan. It says it right in the regs. So that is our response to that. In addition, we presented evidence even at preliminary that the comprehensive plan does call for the preservation of open space, which this cluster subdivision does allow for the preservation of those 20 acres, and is generally conforming in the sense that it's residential use in a residential zone, that the surrounding lots are of a similar size, and some of the other information we presented at master plan. So finally, the last point of the appeal is in regard to, didn't come out right. The last point of their appeal is in regard to the right to appeal. So apparently they did not understand at master plan or anywhere in the process before it came up at the preliminary plan hearing that they had the right to appeal. However, as I've just elaborated on for a good 10 minutes of your life, we all have to rely on the Coventry subdivision regulations, the Coventry zoning ordinance, the Rhode Island state law. And that's where I get my information as to how we have to plan these projects and how we have to proceed before, whether it be the zoning board or the planning board. And they have that same opportunity to get that information. It's printed, it's available. If they don't want to hire an attorney, they have a duty to do their own research. Finally, my last point with regard to the criticism of the language of the notice, the purpose of the notice is to bring people here to discuss these projects and how they fit into the community with the board. And that has been accomplished in this case in a manner that's greater than in most cases. So that's a summary of what I have put in my proposed findings of fact and the positions of the applicant. I have with me Mr. Swarsa, who testified at the preliminary plan hearing and who had assisted in designing the project. And we'd be happy to answer any questions of the board. Thank you.
Thank you. Okay. like at this time, the board to discuss, deliberate the findings of facts that was. Okay, I would like the board,
I think you turned it up. Sounds worse.
hello,
It's very faint.
I'd like the board to deliberate and discuss, the findings of facts that was submitted by, the applicant and also by the appeal. This time here, oh, and I'd like to also enter to the record that Mr. Lockley has entered the, building for attendance. Keith, I'm going to start with you. Looking at the findings of facts submitted by the applicant, let's look at that one first. I think they looked at the whole thing, and I believe him where he says he's not doing, he's not giving facts on, not my backyard. I feel the applicant has reviewed everything. Lack of support by evidence of lack of support weighed by the evidence. Well, I didn't find anything that was blatant and done something for support of an appeal at this time. And then also go clear error. Well, the comprehensive plan was adhered to. I couldn't find an error on that. Planning Commission. The comprehensive plan, I think all rules were followed. Again, I didn't see where there was a blatant error going through any of this. How do you feel, Keith?
I don't find any clear errors in the application here. It appears from what I see that all the I's are dotted and the T's are crossed. They have what they needed to have, they have. The cluster development is permitted in that area. It is permitted, and it is permitted in the comprehensive plan. As far as the procedural error, I'm going to ask Mr. Angel, what is the town's burden regarding that? Do we have to announce an appeal process during a planning commission meeting, or is the burden on the applicant or the public to retain that knowledge on their own?
I don't think the planning board is legally bound to announce the appeal process because the subdivision regulations provide it. And the law requires that anybody who's interested in the information would go to the subdivision regulations. But I understand that they're not lawyers, but the subdivision regulations are for everybody. They're not just regulations for lawyers. They provide the process for anybody. It actually provides the appeal process from the planning board to the zoning board to the Superior Court.
Yeah.
At each step of the way, after master plan, after preliminary plan, and after final plan. So I'm sympathetic that they may not have been aware of it, but I don't believe that's a burden. I believe there was some confusion about understanding that process, but I don't think it's a clear procedural error that qualifies as reversal.
And I agree with you. Yeah. So as far as I can see, I don't find any clear errors to overturn, Mr. Chairman,
Okay.
myself.
Ross?
No, I agree with everything you guys both have said. It's not, from what I've heard, it's their responsibility to find out the procedural stuff. And I don't think there's anything, I don't see anything wrong.
All right, Lonnie?
I agree with the three of us. Said exactly the same thing. I don't think I need to reiterate everything that we've already discussed. I'm in the same boat as the other three.
Ed?
I also agree, I think,
I think the situation, they might have been a little bit confused because it was a preliminary approval. So one of their biggest complaints was that there was no DEM and there was no other things already approved. But that's the way the process works, I believe. So I think that's what led up to a lot of this. But I don't think the planning board made any mistake at all. So I agree with you guys.
Okay. Russ, I know you came in late. but it's
No,
cool.
I've been staying with this whole thing and, matter of fact, it just came from the fire station and, we had a call, that's why I'm late, but, totally agree with everything you said tonight. Like you said, the whole thing revolves around the word preliminary. This is just how it works. It starts and this begin and then moves on from there. So, I don't think that they erred at all.
No. I know people are passionate on both sides.
Oh,
and
absolutely. You can
Even
understand.
at the meeting, I read the transcript of the planning commission was divided. It wasn't, I think there was 5-3 or there was 3 dissenters. So they weren't all united, on it. So not everybody's going to be happy. So, but you just have to follow the weight of the evidence, in my opinion. And,
Okay, so we're also at the same time here discussing the findings of facts from the applicant. And that's where, Mr. Cronin came in. And so you do not find an error in how the whole thing was presented by the applicant to the planning board. Am I correct?
on this, I just noticed some typographical errors. They said we had a meeting on October 5th, but we didn't. I don't think, does that matter, does it? It said on October 5th, the publicly noticed hearing was held by the Coventry Zoning Board of Appeal in regard to this appeal. We didn't have that meeting till November.
Right, November 30th,
Right, but this says
November
October 5th.
30th.
But
Right, but that's well, no, that's the attorney's memorandum he submitted. I can't change
okay,
that document.
all right.
Okay. All right, but it's a good thing you brought that up. Okay. Anybody else have any discussion on this? Okay. With the findings of fact submitted by the appealant and by the applicant, with this information that was given to us and for us to review, I would like to hear a motion that we vote on this tonight.
So moved.
Okay, Russ, you're gonna make the motion?
Second.
Seconded by Ed. All those in favor? By voting aye?
Aye.
Aye.
Okay. Any nays? Okay. So, aye for a vote tonight. Okay. So, at this time here, just to cover myself, I'm gonna do the 5 that heard the full summary, and then Russ, I'm also gonna have you vote too. Okay, just to cover. Okay, and the vote is gonna be to,
Are we voting to uphold or we?
uphold, that's what I'm saying, uphold the decision of the planning board or to reject. All right, so you're gonna have to vote either favor of the planning board or uphold or reject. Okay, I'll start with I'm gonna start with myself. Chairman, I vote to uphold the planning board's decision from the information given from the hearing we've had and from the findings of facts from both parties. Keith, how do you vote?
I vote to uphold the planning commission's decision.
Okay. Ross,
I vote to uphold the planning commission's decision.
Lenny,
I vote to uphold the planning board's decision.
Ed?
Vote to uphold the planning board's decision.
All right, so there was no clerical error means of anything that we could see or hear. Russ, I'm gonna ask you to vote also, just for the record.
I vote to uphold.
Okay. All right, at this time here, the planning board's decision has been upheld. I'm gonna return to our attorney.
Mr. Chairman, I did hear the board say, based upon the record that was presented and the findings of fact presented by
Both parties.
both parties,
Right.
because Mr. Obviously, you ruled in favor of Mr. Cronin. There was a clerical error on his findings of fact, but outside of that clerical error, I would ask the board to adopt one set or the other. One set of facts or the other. The decision is yours, and then I've got the basis of your decision based upon what was said and what the board had said, but the findings of fact laid out by Mr. Again, Cronin would make more sense.
Laid up by Mr. Cronin, I believe, is correct. That's how the board finds. I just want to make sure that we recognize the findings of facts also submitted by Arthur Virginia for the appellant, that we reviewed it, gave it complete thought, but we found out, we found the decision I believe the board made that we found no clerical error and find it in favor of the applicant.
The applicant. And the only reason why I'm bringing that up, Mr. Chairman, of the board, because obviously Mr. Rustigian didn't, he drafted this the best he could. And I don't, there are differences in the set of facts. So if you're accepting Mr. Cronin's facts, then I'm going to adopt those facts in the written decision and then put the basis of decision accordingly. I don't want to, because the court, I don't want to get confused between the facts. I know you're acknowledging that you reviewed Mr. Rustigian's facts, but I believe since you upheld the planning board, you are accepting Mr. Cronin's set of facts.
That's correct. Am I assuming correctly by the rest of the members of the board?
Yes.
Okay.
With the minor clerical error that,
Well, yeah, there's some dates, the dates that are not correct.
the date that's correct.
Yeah, several of them, yes.
And then we'll make sure that that's correct. And then I'll look through the record to that effect. So the facts would be accordingly the standard of review. And then I took notes on the board's deliberations, which will be the basis of your decision,
Yes.
the minutes, the record, and then your comments made tonight. And as I indicated to the chairman prior to the board, because the statute indicates that a decision has to be issued within 10 days of closing the public hearing, I would ask that you keep it open until February 1st for ratification of the written decision. I'll generate it, I'll circulate it, I'll give it to Mr. Cronin, I'll give it to Mr. Rustigian accordingly, and the board can vote on to ratify it to make sure there's no well, they won't get it to you ratified, but
Make a motion to keep the public meeting open for 30 days.
to
Until-
February 1st for the purposes of ratifying the decision.
In purpose to ratify.
I'll second that.
So we're gonna keep going to subject to ratification. Okay, all right. I'll start with Ed. How do you vote on that?
I
You approve?
approve keeping the
Russ? I also approve. Keith?
Approve.
Ross?
Approve.
Lenny?
approve.
Approve. Okay. This would be ratification on February 1st. Okay. Is there anything else we need to discuss?
If there's any other comment by the parties, there'll be a decision on that day. I guess there's a young lady that wants to have something.
Yes, ma'am.
Mr. Chairman, can I just interject because it relates to the motion that you just took? Would that be a 6:00 PM start time for your February 1st meeting?
I believe so. We want to separate it out.
It needs to be separate. I'm just verifying the time because I want it for people that are
Do we
here.
need an hour just to ratify? 6:30, 7:15, yeah.
Okay, 6:30.
Okay.
The board would like to do, I believe, 6:30. on that night,
February 1st.
February 1st.
Thank you.
Okay. Yes, ma'am.
Donna Estigian, 401 Hopkins Hollow Road, Green, Rhode Island. Clearly, I'm not happy, and I'm going to say that my co-applicants, what do you call us? Appellants, they're not happy either. And I do have a question because clearly the residents in this area have to be able to have a say. And how do we get to have a say of what goes there? Because the applicant is going to clear the land, build 7 houses, 4 bedrooms. That's a lot of people. And that whole area is rural. These houses are not going to look rural. They're going to be ticky-tack houses, McMansions, and they don't fit. And it's going to be a nightmare. It's going to impact all our lives. And I want to know from the planning board to the zoning board, how do we have a say in all of this, aside from going to the comp plan meetings and having us say there? How?
I think you just answered your own question. You went to the comp plan
Yep.
meetings, and that's when you have your say.
How did this cluster development get into the zoning regs?
Oh, that I would not know.
But you've been on the board for a long time.
Yes, I have, but it was done before I was around the board.
How do we get it off?
You'd have to go to your council. That would be a council.
Oh, I had conversations with them before he even got elected.
That's
Doesn't seem to be a priority of his right now.
okay.
We're furious.
Oh, I understand. Exactly.
We are furious. And all those people that buy those houses, because Studley is going to clear everything down and he's going to build these houses. He's going to take his money and he's going to hightail it out of there. And you can tell him I said that. I'm so pissed off.
Man, but
Sorry.
I think you're right where you should go right to your councilman. And if you want to change the planning and all the rules and regulations, we have to stick by the rules and regulations presented to us. But you're right, that's where you go, right to your council.
I'm beyond
Also, the town
pissed.
planner, I think, can address you.
You know, my husband and I, he's been on this property since he was born. I moved out there with him. We built this beautiful house. There was a house there. It had long since been dilapidated. We tore it down. It's not like we cleared land like he's going to clear land. You know, he's in it for the money. Money's great, but you know what? We're killing the planet. Greed. You know, greed does not win. I'm sorry.
Okay, I think the planner would like to address.
Sorry.
No, I'm sorry. Just, I can be a person that can help to answer that particular questions outside of the venue for tonight to
Okay.
go through a couple things. We'd be happy to either talk on the phone, email trade, sit down and chat
Okay.
with you. Just
Yeah.
give me a buzz.
I'm thank you
Thank
for
you.
listening to me.
Okay, I would like a vote to adjourn the Board of Review, Board of Appeals, I'm sorry.
So moved.
Second.
Seconded, okay. All those in favor say aye.
Aye.
Nays, ayes have it. Thank you all for coming tonight.
Oh, yeah, yeah, yep. It's just throw it in the file.
It's still totally outnumbered. I mean,
I don't disagree. What we can do. I don't disagree. Yeah, for the board.